Mentioning original side.
Yeah, my lord, kindly to mention execution matter, my lord, of 2023, my lord. The award is of 2015, my lord. No stay subsisting, my lord. There was an order was passed, my lord. It was lastly appearing as item number 63 in your lordship's list of 6th of August, my lord, last Wednesday, my lord. I'm only beseeching, my lord, if your lordship only considers, my lord, and my lord, I will not be beseeching your lordship to upgrade, my lord. I understand your lordship does not.
We'll see, Mr.
My lord, may I only just hand over the number, my lord? That is all.
Just hand over the number, but I'm not going to.
Very well, my lord. I won't leave it to that
Upgrade.
to your lordship. Great.
My lord, may I have my lord's leave to mention for inclusion a section 11 application? My lord, I was only humbly praying if it could appear in the list tomorrow because they're connected section 9 applications which are appearing
My
tomorrow.
learned friend has given a notice to
But
me at 10 a.m., my lord.
Yes,
10
I understand. I'm only asking for inclusion if it
I
commences.
am not
It's a fresh
objecting to
section.
the inclusion, my lord. But
That's all. If it could be included tomorrow, my lord.
He's just asking for the inclusion tomorrow.
no, I am not objecting, my lord. This is that matter where my learned friend was supposed to take instruction that whether they are willing to go for arbitration or not. Those
We
two
filed a
group
section
matters
11
will
for
not. Now they have filed a section 11. We shall point out what is their case in section 11 whenever matter is taken up.
problem. If it could kindly appear tomorrow, my lord, that's my humble prayer. Problem.
My lord, other matters are also coming tomorrow.
Yes.
Daily list. Extension of interim order item number 3.
My lord, it is appearing at my instance, my lord. Now, my lord, on the last occasion, there was a rejoinder which had been filed, my lord, by the opposite, the respondent, my lord, is the Tolly Club matter, my lord, where they have included certain documents. Now, my lord, my interim order in the meantime has expired last week, my lord, on Thursday.
Yes.
7th, my lord.
My lord, I'm praying for a leave to file my supplementary evidence. Some document has been included in my affidavit in opposition. But it may be.
You appear for the state.
I am appear for the Kolkata Municipal Corporation.
My lord, may my interim order be extended and I may get an opportunity, my lord, to file a rejoinder to this rejoinder, my lord, which they have sought to file, my lord.
What supplementary affidavit are you?
Some documents has been misplaced. I mean, that has not been included. Although there is statement.
My lord, if your lordship recalls, Mr. Kaur had appeared on the last occasion. He had indicated that he'd like to incorporate a few more documents which he had been able to lay his hands on. Now, my lord, there are now certain few new contentions which has been brought in, my lord. So we would be required, my lord, to use a short rejoinder to this. New documents have been introduced, my lord, now.
Supplementary affidavit. Filed by the respondent, Calcutta Municipal Corporation, is taken on record. Learned counsel for the petitioner seeks and is granted 3 weeks, 2 weeks.
My lord, 2 weeks would suffice.
2 weeks.
3 weeks, very well, my lord, 3 weeks.
Time to file it.
Since the club, my lord, that's the reason why 3 weeks would be better.
3 weeks to file his reply to the
Supplementary affidavit.
supplementary affidavit.
Affidavit in opposition, that is how they have worded it, but they have already filed their affidavit in opposition.
Affidavit in opposition, you have already filed it.
They have already filed and we have also filed our reply.
Reply to
So
that.
perhaps this should be
It
treated
will
as a
be joined.
supplementary affidavit. Or a
Supplementary
rejoinder.
affidavit. The supplementary affidavit filed by the petitioner is taken on record.
My lord, the respondent, my lord.
By the
By the
respondent.
respondent,
And
yes.
he seeks and is granted right to file his rejoinder.
Shall rejoinder. And my lord, the interim order may be extended.
The order granted earlier, which has been extended from time to time, is extended further for a period of 8 weeks.
Great. Deeply applied.
Awesome.
List after. When do you want?
Lord, after 3 weeks, whenever you propose it. Great.
Restoration application item number 4.
Lord, this is my application or in connection with the section 11 application. But initially the section 11 application was allowed, but at the time of naming the arbitrator, the nobody will appear and matter will dismissed for default. The
No, there's a huge delay.
uh, from the date of knowledge there is no delay. And if your lordship
Delay of 1921 days.
something I file a separate application for
Does
condolence.
not explain anything. Huge delay, sir. Who's appearing on the other side? So, Madam, Union of India is the party. Take down. This is an application filed by the petitioner seeking condemnation of delay of 1921 days in filing the application for restoration of AP 162 of 2003. Full stop. Learned Counsel for the petitioner submits that the report in order dated 11th December 2019 dismissed the
ওই তো
petition
আমাদের
for
petition এ রয়েছে তো।
non-prosecution. It is submitted that owing to his family circumstances and medical condition, the petitioner, who is himself an octogenarian, could not take appropriate steps for seeking the restoration of the petition within time. Learned Counsel for the Miss So-and-so, none appears on behalf of the respondent, Union of India, Miss keep forgetting, Aparna Banerjee. Miss Aparna Banerjee, who appears for the Union of India, is being asked to assist in the present matter since she is there in the court. Full stop. Let her appointment be regularized. A copy of the petition shall be handed over to the counsel for the respondent during the course of the day to take appropriate steps. She prays and is granted 3 weeks time to file her affidavit in opposition to the present application. Reply, if any, within 1 week thereafter. List after 4 weeks.
Grateful.
After the petitioner, I use my 29A
Item
application.
number 5.
For the respondent. Are you opposing?
What is troubling me is the pleading, the way they have placed the matter argument is concluded.
Then
Only thing is that one should be cautious about this type of making statements.
This is
That
only for the passing of the award, your lordship.
kindly
Sir.
see their statement is
Pointing
that
out
they got a leg injury and complete bed rest. Kindly see page 9, paragraph 14. Kindly see the corresponding document at page 38. Let's forget. But that's why I started my argument that I cannot oppose because I should not. But at the same time, a petitioner appearing before the High Court, they should be cautious about this type of making pleadings.
Lordship,
Just
it was
taking the
it's
court
the
as such a casual manner.
happened with
should not be
myself, your
accepted.
lordship. It was a bad accident that I went through.
accident, but then look at this.
Simple, sir. I know lordship's view is that argument is complete, my lord. Record my opposition, my lord, that I have objected to it, and my lord kindly extend.
Objected on what ground? What ground?
My lord,
The ground that the medical certificate and the statement made in the petition is
no, my
contrary
lord.
to each other.
Kindly, in that regard, my lord, kindly see page 9, paragraph 13.
Yes, that's what I'm saying.
That argument was concluded 10th of April, and next date was fixed on 5th of May.
Yes.
But from 10th of April or 5th of May, the arbitrator could not complete the passing of award. By the time argument is concluded.
Yes.
So that is, my lord, it goes, my lord, the arbitrator ought to have passed the award by that time. Only this.
Just because you have to raise some allegation, you have to raise that.
It's not an allegation, my lord. It is their statement. It's a matter
Now,
of
there's an application filed by the petitioner under section 29A4 of the Arbitration Conciliation Act seeking extension of the mandate of the arbitral tribunal and for publication of the seeking publication of the award. Full stop. Learned counsel for the parties submit that the matter has been concluded and it is kept for publication of the award, and the arbitrator has kept the matter for publication of the award. Full stop. It is further stated that the parties had mutually extended the mandate of the arbitral tribunal till 7/5/2026. Full stop. Upon consideration of the material placed on record, this court is satisfied that no undue delay has been caused by the learned arbitrator during the course of the arbitral proceedings. Keeping the advanced stage of the arbitral proceedings and in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of 3 months. 3 months. 3 months
only passing of award.
for publication of the award. 3 months. Full stop. It is requested that the learned arbitrator shall publish the award within the extended time period. With the aforesaid direction, the present petition stands disposed.
Obliged.
The sole arbitrator, right?
Again. Acting.
Item number 3, I'm appearing for the applicant. Now, Your Lordship, by an order dated 5th January 2026, had earlier extended the mandate of the arbitrator for a period of 6 months.
Page?
That's at page 44, Your Lordship.
Yes.
Your Lordship, subsequent to passing of Your Lordship's order, the Supreme Court had passed an order dated 29th January 2026, holding that the principal civil court will have the jurisdiction to extend the mandate. Perhaps this court now does not have the jurisdiction to extend the mandate because it's not the principal civil court. Just hand over.
In this matter,
Not in this matter. The judgment is not in this matter.
so you withdraw it, you file it, it's not mine.
Your Lordship, there's a confusion that Your Lordship had earlier passed an order dated 5th January extending.
But it is, today you feel that you should go before the city civil court, you go before the city civil court. Who's stopping you? Learned counsel for the petition seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law. Full stop. The present petition is dismissed as withdrawn with liberty as prayed for.
Grateful, Your Lordship.
Item number
I am
7.
Yes.
My lord, I am appearing for the petitioner. It's a
Settled now. What's the difficulty? And now don't ask for anything. Yes.
no, it's for extension of
Oh, this is a different one.
29A, my lord.
Now what is the issue?
Issue is that in AP,
Same client.
same client. No, yes, same
Yes,
client.
yes, same client.
Same client, same client.
Yes, tell me.
Mutual consent of extension of the arbitrator expired on 16th of July this year.
16th of July.
Yes, my lord.
Arbitrator appointed on
27th August 2024.
27th August.
Yes, my lord. 2024.
Readings completed on
20th February 2025.
2025, right?
Yes.
20th February. And this is the first extension.
Yes, my lord.
Take that. The petitioner has preferred the present petition under section 29A4 of the Arbitration and Conciliation Act seeking extension of the mandate of the arbitral tribunal for conclusion of the arbitral proceedings and publication of the award. Full stop. Learned counsel for the petitioner submits that this court, by order dated 27/8/2024, appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 20th February 2025. Full stop. With the consent of the parties, the mandate of the arbitral tribunal was extended for a period of 6 months till 15/7/2026. It is submitted. What is the stage?
Argument stage. Argument of the
The
respondent.
learned counsel for the party submit that the matter is at the stage of final argument. Full stop. Upon consideration of the learned counsel for the respondent does not have any objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the materials placed on record, this court is satisfied that no delay is attributable to the learned sole arbitrator in conducting the arbitral proceeding. Having regard to the advanced stage of the arbitration and the interest of justice, the mandate of the arbitral tribunal is extended further for a period of
6 months.
6 months. 15/7/2026. 15. It's 15 or 16?
15th.
15. Sole arbitrator, right?
Yes, sir. Oblige, my lord.
Item number 8.
Right. This is my application for extension of mandate under section 29A, my lord. May I file the service, affidavit of service? It's also Union of India and
What are you filing?
this is a application under section 29A for extension of mandate, my lord. I am filing the affidavit of service.
Who's on the other side? They are participating there before the arbitrator?
Yes, they participated and also they give their consent, my lord. At page number 18, my lord, the direction of the arbitrator is given, my lord, at point number 4.
For publication of award.
Yes, my lord. The mandate expired, my lord, on 12th of June 2026.
Take down. Paragraph this court by order dated 15/7/2024, appointed the sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 13/12/2024, and with the consent of the parties, the mandate was extended for 6 months till 12/6/2026. Learned counsel for the petition submits that the matter is at the stage of passing of the award. Publication of the award. Upon consideration of the material placed on record, the court is satisfied that no delay in the conduct of the arbitral proceeding is attributable to the learned sole arbitrator, having regard to the advanced stage of the arbitral proceedings and in the interest of justice, the mandate of the learned sole arbitrator is extended further for a period of for how much time?
The arbitrator indicated 6 months till 11th of December 2026.
For the period of 4 months.
6 months, man.
4 months.
4 months, man.
Just for award. 4 months from today, the sole arbitrator is requested to publish the award within the extended time period, with the aforesaid direction that the petition stands. Despite service benefit.
Item number 9. This is my application for review of the order.
Yes.
You have my advocate on record that has not served the other side. Kindly, may I come back tomorrow?
Petitioner seeks and is granted 1 week time to serve upon the respondents.
Loss. Item number 10. Number 1, 2, 3.
My lord, by my lord, this is the application under section 11
Learned counsel for the respondent number 1 to 3, my lord, appeared before your lordship, filed their affidavit in opposition. I have used my affidavit in reply, my lord. My lord, certainly by filing the affidavit in opposition, my lord, my learned senior friend given the correct proposition regarding the necessary party, my lord, in respect of this application. Because, my lord, although, my lord, in affidavit in opposition, my lord, they have not given any death certificate of the other brothers, my lord, but they have given the date when the other brothers have been, my lord, demised. And, my lord, the predecessor in interest of the respondent number 1 to 3 being the brother of, my lord, the original owner of the property, my lord, after the date of the original owner of the property was there, and subsequent the other brothers, my lord, the predecessor in interest of respondent number 4 to 13, my lord, died prior to the death of, my lord, original owner. So, my lord, only the predecessor in interest of the respondent number 1 to 3 being the brother, my lord, comes under the, my lord, uh, Hindu Succession Act, class 2, my lord, entry 2. My lord, that is, my lord, certainly the correct proposition, my lord. The rest of the parties, my lord, might be, my lord, deleted. Other than, my lord, regarding the dispute, my lord, I have stated, my lord, I have tried to perform the act in accordance with the development agreement. I have made certain expenditure, my lord, of 17 lakhs 56,000. They have, my lord, admitted that they have received 12 lakhs out of 17 lakhs 56,000, my lord. So,
Settlement talks are going on, right?
But the talk of settlement was going on. We are still open for the development work. But since they want, we are no way standing in the way of development work. We have stated it very clearly. If they want, they can still perform their duties under the agreement. Now they,
my lord, lot of time, my lord, already went out, my lord. At this point of time, the petitioner only, my lord,
for the
paying
delay,
for
we
the
are not responsible, my lord. That is the
Sir,
thing.
who is responsible, who is not responsible, my lord, certainly be adjudicated at this point of time. Now, my lord, a lot of time, my lord,
Now you are seeking relief only against
I am paying, my only relief is, my lord, before your lordship, that
which respondent?
my lord, respondent number 1 to 3, that is, my lord, correctly, my lord, proposed by my learned senior friend, my lord. The other respondents should have been deleted, my lord, because after affidavit in opposition, I got to know, my lord, the other brothers, my lord, have died prior to.
Application. Get the other respondents deleted.
Mm.
File a fresh memo.
My lord, then I have to, my lord, expunge those names, my lord.
Have to.
My lord, certainly, my lord. Then, my lord, kindly make an one-line order, so, my lord, I can expunge those, my lord. By filing the application, I can expunge those names, my lord. Then your lordship will appoint the arbitrator, my lord.
When I prepared application for this, for getting the name of the other person.
My lord, certainly, my lord.
Along with the, there's no need to record anything. Learned counsel for the petitioner states that respond number 4 to 10, 11 shall be deleted from the array of parties.
4 to 11, my lord.
4 to 11.
4 to 11.
He shall take necessary steps for amending the, what do you call, cause title here?
Yes, my lord, from the cost title.
The cause title.
But I believe
Within a
the
period of,
pleadings are also required to be changed. The pleadings are also required to be changed in that.
absolutely everything has to change.
My lord,
You're seeking relief against. How
Actually,
can this be done like this, sir?
that will be in the form of an amendment application. my lord.
Amendment application, or
Have
you
to
withdraw
file,
this
because-
petition, file a fresh petition.
Yes, my lord, my lord, but after subject to correction, my lord, the filing of fresh, if your lordship, my lord, grant me opportunity to file the amendment application, that would be, my lord.
Amendment application, you will be seeking everything amended.
My lord, I
You
have
should,
to,
in
because, my
all
lord,
fairness,
what,
you should withdraw this and file a fresh petition.
because, my lord, the only difficulty is after they have filed their affidavit in opposition, I got acquainted with all those facts, my lord. Prior to that, my lord, I did not have the knowledge.
But I'm leaving it to your lordship.
Can't be done in amendment, sir.
It's unless and until the entire pleadings are amendment, nothing.
Absolutely. You should withdraw this and file a fresh petition.
My lord, then kindly allow me 1 week, my lord, because I need to take the instruction from my senior as well regarding this.
Can't go on like this. At least when you come
I
to that home, you
understand, my
should
lord.
do your homework and then come.
No, my lord, it's absolutely, my lord, correct.
You just can't make
Which has
everybody
fallen
parties
from your
and
lordship, my lord. I need to withdraw the same, but I need to take the instruction from my senior as well, my lord. Allow me only for
করতে পারবে
limitation time set করতে পারবো। Allow me a week, my lord. Kindly, grateful.
grateful adjourn for this week.
adjourn for this.
Only for this. I don't think so. The limitation is the same. So the-
Item 11.
This is my application, my lord. My lord, in terms of agreement, Section 11 application is filed. Last occasion on 28th July.
Where's the other side?
The side is not appearing today, my lord. Last occasion they have.
They were there last time.
Asked for filing an affidavit opposition. Last opportunity, and your lordships. My lord, agreement at page 16.
Yes.
And the arbitration clause as page 20, paragraph 18.
Yes.
And notice was sent on page 79. Last paragraph for signify consent of appointment arbitrator.
If we go with this notice, then it is barred by time.
My lord, they have filed a consumer forum application after this. And if
That's
my
all right. That's for you to defend.
that will be
their-
decided by
that
the
I'm not concerned with that. I'm saying if we go by this 21 notice of 2020, it is barred by limitation.
that will considered by the arbitrator, my lord.
No. That will be considered something by me in section 11.
My lord, if it is limitation, 21 I have in the year 21 I have filed this application. They have filed in the same agreement in the year 22 before the consumer forum.
Oh, this petition has been filed in 21.
Yes,
This section
my lord.
11 is pending since 21.
Yes, my lord.
Oh, all right. I thought it's fresh. Since 21,
Yes.
So from 21 to 26, the matter never came up for hearing.
Several occasions, my lord, I have tried to mention this matter to listing, but I could not. Two or three occasions, my lord, direction was passed for a filing affidavit in opposition, but they could not.
What was that page number? Your notice page?
Notice at page 79. My lord, page 80 to last refund amount on 8/6/2020.
8/6.
2020, page 82.
What is this agreement which you had entered into?
So, my lord, he has entered into agreement for purchase of a land. Thereafter, he chose to not proceed with. My lord, kindly come to page 18 of this agreement.
Yes.
Page 18. Last but one paragraph. In case he choose to refund, my lord, the second party shall make an application for refund of the deposited amount. First party shall refund the amount, deducting 40% service charge. And second party within 30 days. My lord, according to that, he make an application and my lord, the refund was made. My lord, in my notice, I have stated all this amount. My lord, he have paid the amount. My lord, I have refunded the amount and he received that. Page 82, last receipt was made on 8/6/2020 by check number such and such. And he is claiming 40%. That is the dispute. Therefore, I am seeking for consent of appointment of arbitrator. Apart from 40% amount, I have paid all this amount. The dispute of 40%.
So you were supposed to pay the amount and get the land registered in your name.
I have ready to register, but he is not choose to register the document. That's why he make an application for refund. And according to clause, my lord, I have refunded the amount after deducting 40%. That is the dispute decided by the arbitrator. They want the entire amount.
Have to see this. And they had gone to the consumer court. Order has been passed in their favor.
Ex parte order obtained, my lord. Suppression this fact. In the year 21, this petition is pending before the honorable.
Where is that order?
My lord, last occasion I have filed a supplementary affidavit. Your lordships considered and passed this.
State honor appears for the respondent. This court by order dated 28 July 2026 had granted the last opportunity to the respondent to file his affidavit in opposition. The same has not been done till date. The right to file the same is closed. Let this matter be listed for hearing. Next week is Kolkata. I have to see the file.
Yes, my lord.
I have to see the file. Keep it for next week. ऊपर रखना matter.
Item number 12. My section 11 application. Development agreement. I am the developer. I seek specific performance. We have a section 9. In the section 9,
Other side.
it's after affidavits.
That's the other side.
Don't see them appearing today.
Readings are completed. Who appears?
My lord, the affidavit in opposition has been filed.
Yes.
I'll tell you, lordship, by who.
You want to file your reply to that?
I have not. We've served the copy also, the reply. May I just file it formally?
Reply to the affidavit on opposition is taken on record.
The agreement is admitted.
They should be heard.
They should be heard, yes.
Reply to the affidavit of opposition filed by respondent number 1 to 3. Taken on.
I will be the next week as well. I'll serve notice and come back. Come back week after next, not
week after next.
Very good.
Lordship, yesterday your lordship had tagged this matter with another commercial
Yes,
application.
this is that
section
matter,
11.
my lord, where I am humbly submitting before your lordship that since it has been filed in the non-commercial division, and after that practice direction, so it cannot be transferred.
It can be transferred.
My lord has
Every time you come up with some very difficult
no.
forces people to.
We are issuing fresh 21 today. Now, my lord, before that,
Yes.
I found this matter may be settled. I have taken categorical instruction. Why I say so? Ultimately, at the end of the day, they will be asking for specific performance of the development agreement. This agreement had 1.5 years tenure, and I am to get 42% in 21 one landlord, 21 other landlord, total 41% as per the agreement annexed by them. My lord, let us agree to this agreement, 1.5 years, let it start from tomorrow with a default clause. I
can't change that.
My lord, I have suffered from 2003. Even then,
I can do nothing about it.
my lord, I am proposing this this settlement to her.
Propose them outside the court.
I tell your lordship, they do not. They just want to by hook or by crook. My lord, they want to lock the land from 2003. Today we are in 2026. Even today, I am giving a proposal. It is their agreement drafted by their lawyer.
Settlement talks is outside the courtroom. You give a proposal. If they like the proposal, they are agreeable to the proposal, they'll accept it. If not,
Well,
we have to.
subject to correction by your lordship. Ultimately, at the end of the day, this is the highest they can get from the arbitrator.
It's not for me to see. This is for them to realize. It is for them to understand what they can get.
May I request only your
You're
lordship?
not sitting here in mediation.
No,
not my job.
My lord, may be pleased to send this matter to mediation. Mr. Somrat Sen, learned senior advocate, was appearing before your lordship. I am even ready to go before him. He is a reasonable person, and we all like him as a lawyer. I am ready to go before him even. Let the matter.
Your Lordship, it was kept for hearing on 19th, so tagged with the other matter.
That's right, but he's proposing a settlement talk. What is your view on that?
Come back on 19th with
Well, I am
instructions and
proposing whatever they can get at the highest.
we'll come back on 19th and then.
This has to go on the commercial side.
My lord, then my lord, kindly hear me. Then my lord, may be pleased to send it to commercial division. Kindly do not send it transfer. We have got some submission. I have considered.
You always have a submission.
I have
forced me to pass an order in 21.
I have considered the
I should have dismissed with cost.
For cost, my lord.
This one, I'll definitely impose 1 lakh rupees cost for sure. You argue and I'll impose cost.
No.
110% I'm going to impose cost. This is not going to happen. You're not going to waste my time. You wasted 3 hours of my time on the other occasion.
We'll get scared before your
No. Let it be. It's better you're scared.
No.
At least you'll make my life easy, not your life easy. I'm going to impose cost. You argue.
Today we are issuing fresh 21.
You argue this matter. I'm issuing cost. Last time I didn't do it.
In that matter, client.
And I repent not doing it.
Not in this matter.
I repent not doing it.
Not
yes.
That matter, client had the capacity. I tell you, lordship, but not in this
Don't
matter.
worry. I'm not concerned. Last time I left it. This time I'm going to impose.
Absolutely. Absolutely. Kindly appreciate my bona fide before your lordship.
I have appreciated your bona fide, your arguments and everything. And this time also I'll appreciate. But I'm telling you, I'm going to impose cost.
Kindly see the details of the landlord.
Yes, please go ahead.
Kindly see the details of the landlord.
Whatever. I'm not concerned, sir. I'm not. You're wasting my time. Judicial time should not be wasted.
That is why let us come back on 19th. My lord, send it to mediation, even to their learned senior advocate.
First, you agree for the matter to be sent on the commercial side. Then you talk about your settlement talks. Let me see your bona fide. Let's see your bona fide. Then we'll see their bona fide. First, let me see your bona fide. We'll see on the 19th both the matters.
On the 19th, my lord, maybe in the other matter, I am not there. In the 19th, my lord, I may always come back to your lordship, but my lord, kindly appreciate that in this matter, my lord, I believe that this matter may not be transferred. Now, I have advised my client in this regard. Now, if your lordship directs me, I'll certainly bow down to your lordship's direction.
So then I'm passing an order. Let this matter be listed, take note. Since this matter arises out of a development agreement, learned counsel for the petitioner states that the same shall be listed on the commercial side. Let this matter be listed on the commercial side in terms of the section 2(1)(c) what? You guys never read the act or what?
2(1)(e). 2(1)(e). 2(1)(e) of the principal civil code.
2(1)(e) what? Roman 145 what?
2(1) numerical 1.
See Roman partnership development.
That is commercial code, sir, judge.
Nah, 2(1) Roman 16. No, this is technology development agreement. Wait.
I will
Development.
kindly come to 2(1)(c)(7).
That shareholder 7.
Agreements relating to immovable property.
2(1)(c), sir. The registry is directed to make the necessary changes and list the matter on 19th. Along with, give the number,
all right.
give the number along with AP Comms fund. We'll see. We'll send it to the arbitrator or the mediator. You want the mediator, right?
And
take instruction to what he's saying.
And my lord, take it from me. I'm sure that they will not go to mediator and they will keep the matter draft.
Take instruction.
Even then, on the last occasion, I proposed another. I gave another proposal. I am ready to give it on outright sale at 80% of the present market value. Even then, no fruitful feedback has come.
We'll see. 19th. Take your instruction.
Yes, sir.
Item number 14.
May it please, Your Lordship.
For the respondent.
My Lord, I'm appearing on behalf of the petitioner. My Lord, pleadings are complete on the last occasion. My Lord, reply has been filed. My Lord, I wanted to rely on certain judgments. Their main objection is they have admitted the arbitration agreement. My Lord, am I audible, Your Lordship?
You're audible, but in between your voice is cracking.
My Lord, I apologize, Your Lordship. No, my Lord, they have admitted to the arbitration agreement. However, my Lord, they are only opposing on the fact that the claims are time barred. If Your Lordship kindly allows me to, I'll come back physically, if Your Lordship.
But on the last occasion also, he said that on the grounds of judgments, he take time. And now again on this, but this is a completely dead but claim. 2007 development agreement, assignment agreement executed on 2011. Thereafter 2015, we have already given the owner's allocation. No words on that. In 2023, he comes up with a notice.
No, my Lord, I'll show the conduct.
21 notice.
I'll show the conduct, my Lord. I am in some difficulty today.
He says that his cause of action arises after he comes to know of a sale deed. That sale deed was executed in 2016 and that was affirmed by him only. Completely lie. Kindly see one paragraph.
Pleadings are completed.
Pleadings are complete, my Lord.
Yes. What
Yes,
is
my
your
Lord, pleadings. My Lord, my difficulty is, Your Lordship, I'm unwell, Your Lordship. That is a different issue. But however, my Lord, if Your Lordship.
Petitioner states that he is indisposed, prays for an adjournment. Let this matter be listed on. When do you want?
My Lord, next week. Anytime, my Lord. Next week.
Unwell is a good ground.
I did not
My Lord,
say
because of the rain, Your Lordship, last day, what has happened, my Lord, the entire city has come to an halt, Your Lordship.
You look unwell.
Very well.
I bow down, my Lord. Grateful.
Item 15.
My Lord, I appear for the petitioner in this matter, my Lord.
For the responding, my lord.
Now, my lord, on the last occasion, we had also submitted before your lordship, my lord, that it can be settled. Now, my lord, the parties have also agreed to sit, my lord. So perhaps
Yes.
it might take another 3 weeks time, my lord.
Parties submit that settlement talks are underway. They pray for an adjournment. Let this matter be listed in the monthly list.
My lord, keeps it, otherwise I again have to mention, my lord,
Tell you what,
3 weeks hence or 4 weeks hence.
after 4 weeks.
Grateful, deeply obliged.
Item 16. Item number 16.
Who's there? लिखा ना कोई ऑर्डर शीट है पहली बार आ फर्स्ट टाइम मेंशन किया यार Then after mentioning nobody comes. None for the petitioner. Dismiss 44.
My lord, I was appearing on behalf of the petitioner's lordship. In item number 6 and 7. Now, all of a sudden, my lord, I was removed from the online portal.
16 also you're there.
Yes, my lord. 16 and 17, my lord, parties are same.
There's no arbitration clause.
No, my lord, there are arbitration clause, your lordship. This is an agreement for specific performance, my lord, of a contract.
Is
Now, my
the
lord,
MOU
MOU.
for
Yes, my lord.
where's the arbitration clause?
My lord, I'll indicate your lordship. My lord, but if your lordship kindly allows me to come back after service because the respondents have not been
Same order.
appearing.
There's no arbitration clause, sir. I can't see it.
My lord, I'll apprise your lordship on the next
Same
your
order
lordship.
as the earlier 115. He's not well. 600. 16.
So grateful, my lord. Item 16 and 17, my lord.
16, 17.
Item number 17.
Same.
18 of it. Item number 18.
Yes.
Ram for the petitioner.
My lord, I have got the respondent. I am led by Mr. P. to Karamala. I am paying for a short pass over.
You have been taking date in this matter. What is it? What's going on?
Pardon,
Any
my lord?
settlement talks?
Pardon?
Any settlement talks?
No, my lord. They have paid for time for last 5 or 6 times, my lord.
Every time. This is the fifth
Short
time.
pass.
Pass over.
Grateful.
Item number 19.
Petitioner. This is my section 11 application. If I'm a developer, executed an agreement with the respondents. Now, what happened, your lordship? This particular agreement, your lordship, was purportedly cancelled by the owners of the property. And thereafter,
Your side.
the other side, your lordship, Mr. Kothari was there and he took a point
he took a point, Your Lordship, that this particular matter should be transferred to the commercial dispute. Now, what happened, Your Lordship, this particular
Oh, yes, yes. Development agreement.
yes, development agreement, the nature of the property is, Your Lordship, residential,
There is a-
Vastu. Okay, now, Your Lordship, he relied on, Your Lordship, two judgments, one passed by Justice Sarkar, Your Lordship, and one division bench. And I am also carrying, Your Lordship, that Ambalal's matter, Your Lordship, what happens in this matters, Your Lordship, the clients then don't take, Your Lordship, any
Not
decisions. We only take decisions, Your Lordship, that whether it should go before the commercial or non-commercial.
Not today. Next one.
Yes.
No, no. There was Asansol some property. That you rely on the division bench.
Yes, sir.
They had relied on the division bench to say
Relied
that
on
all the-
division bench by Justice Basak, Your Lordship, but that try to distinguish it. Ratan Lal's judgment, Your Lordship, two judgments.
We'll see, nobody is here today, so.
One is Ratan Kumar Agarwal
Tuesday.
versus Ashmi Construction.
Thank you.
Yes.
Item number 20.
20, 21 and 22, my lord. This is my section 11 applications, more or less identical. But here, my lord, I'm the sister concern of the promoter who has developed the property, and I'm providing services in terms of the deed of declaration. I've been incorporated. Deed of declaration, which has been submitted by the promoter, has been incorporated by reference specifically in the deed of conveyance executed between the promoter and the purchaser, flat owner. The respondent is the flat owner. The dispute arises out of non-payment of service of common area maintenance charges. There are areas which are due, which despite of demands, they are not paying. I have to satisfy, my lord, that there is a binding, valid and binding arbitration clause between the parties. On the
You had asked for transfer on the non-commercial side.
No,
they had.
No,
it
no.
has been since
I
been done.
had initially filed it before commercial division, but because of the specified value was not beyond that, therefore we requested for transfer. Now, if your lordship kindly sees, the first document here is a registered deed of declaration, which the promoter, who is the pro forma respondent herein. That is, my lord, will find it at page 28.
So the first, there are two agreements, right?
There is a deed of declaration, then there is a deed of
Not a
conveyance.
party to that.
I'm not a party to the deed of declaration, but I have been incorporated in terms of the deed of declaration. The deed of declaration has been incorporated in the deed of conveyance.
Through the conveyance deed, you are seeking your.
I'm through the conveyance deed. Now, the respondent is a signatory to the conveyance deed. The pro forma respondent is a signatory of the conveyance deed. And I have been discharging my obligations to provide services in terms of deed of declaration, which has been incorporated in the deed of conveyance. So, Ajay Madhusoodan principles that since I'm performing the contract between the parties, I become a veritable party. And so I'm seeking invocation of arbitration, though I'm technically a non-signatory here. But then respondent is a signatory, the pro forma respondent is a signatory.
Any reply have been filed by you?
Yes, there's a reply to the section 21 notice which has been given.
That's all.
That's all.
Are you objecting to the, sir?
Yes, my lord.
Are you objecting to the appointment of the?
Yes, my lord. The agreement by virtue of which they draw their power, there's an agreement between the performer respondent, who is the promoter, and they are the maintenance. They claim to be the maintenance body. There's an agreement. My lord will find that at page 87. The maintenance and management agreement.
I'm not invoking that. I have not invoked that.
That gives them the power.
No, that
My lord,
I'm not
kindly-
seeking any invocation around that.
My lord, this agreement was between the promoter and the maintenance body, and this doesn't draw power from the original deed. There's no reference to that effect. There's no reference to the original arbitration clause, and the arbitration clause incorporated in the management agreement is a standalone arbitration clause between them. Whereas he says, my lord, in the arbitration clause, my lord will find that at page 92. The entire, my lord, if my lord kindly peruses the entire agreement, there's no reference to the original agreements which he intends to rely on. Any disputes between the maintenance company and the purchasers, or the developer and the purchaser, to the extent assigned shall be referred to an arbitration under the Arbitration and Conciliation Act. This is why he for the first time comes into the picture. For the sake of this argument, well, he cannot invoke an arbitration clause because he is a non-signatory to the either of the. He could have claimed under the private respondent. I would have understood the pro forma respondent. He could have claimed, but he standalone does not have any authority to invoke these arbitration clauses. That is my substance of the.
File your reply.
Yes, my lord, I'm grateful.
I mean, just one clarification. I have not invoked this arbitration clause. What I've invoked
Part
is the
the
deed of
record.
declaration and the deed of conveyance.
Can't be decided without affidavit.
Very well. Let them file their affidavit. I'll give my rejoinder.
Take down. The present petition has been filed under section 11(6) of the Arbitration Conciliation Act, seeking appointment of an arbitrator for adjudication of the dispute between the parties arising out of the agreement contained in the deed of conveyance dated 29th April 2010 and the deed of declaration dated 24th April 2010. Full stop. Learned counsel for the respondent.
Principal respondent. Principal respondent. There's a perform.
Which one?
Principal
Respondent number one, because pro forma is my lord the promoter.
One and two.
Respondent number one states that the present
One and
application
two.
is
Who's
not
the
maintainable
performer?
since there is no, since the petitioner was not a signatory to the agreement dated 24th April 2010 and thus the present petition is not maintainable. Seeks and is granted 3 weeks time to file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after all.
Grateful, man. Deeply.
That's your primary concern, right? Not maintainable.
That's one of my, that is the
They
primary.
are not
concern.
party to the.
Yes. Other than there are others
There are
which
no-
we
that's
can
not-
hash out before the arbitrator, but this is
Yes.
the primary. My lord, one thing, my lord, I'm the private respondent, principal respondent number 1 and 2.
1 and 2.
Yes.
And the next agreement, next proceeding, my lord, identical, but the deed of the conveyance date is different and the parties are different.
Yes, but then
Deed of
different.
declaration is the same.
No, deed of declaration remains the same.
Only thing my learned friend possibly is appearing for those respondents also.
Yes, my lord, I'm
In
appealing
the
for all the
two.
You appear for respondent number
in
1 and 2, right?
1 and 2.
Nilajri Moitra and
Nilajri Moitra, Rita Moitra.
you appear for both.
Yes, and
दूसरा
440.
भी करना 20. Petition filed for seeking appointment of
448, only principal respondent number 1.
to adjudicate the disputed differences arising out of इसमें conveyance date number change होगा. Conveyance date dated 19th April 2019 and deed of declaration same है 24th April 2010. Objection is the same. Same objection, right?
Yes. Yes. All identical cause papers. Yes. And my lord, 440.
Only the conveyance date is different.
Conveyance date is different.
Conveyance this deed is different.
My case is entirely on Ajay Madhusudan.
And my lord, in the next matter,
Both your respondent number 1 and 2.
1 and 2, first and second, third, there is only one respondent, Chanchol Kumar Mondal. I'm appearing for him.
ठीक है. Respondent number 1. इसमें conveyance date dated 4th August 2000.
Ajay Madhusudan has given us a lot of
24th April. 1. There's only one respondent.
Ajay Madhusudan judgment has given the non-signatories a lot of leeway.
Lot of leeway, but
Probably, but the 2024 bill, if it's
No, but I'm not on
ST,
2020.
it takes shape. Earlier bill had incorporated the definition under section 8 and section 45, but section
But
2
those have
remained
not been,
unamended.
those have not been given.
how your
effect to.
conveyance deed has
20
actually
2050 has
incorporated the deed has to be.
Yes, yes, that I'll show. Deed of conveyance, all terms, and even conveyance also has an arbitration clause.
Standalone arbitration.
Yes, yes, that they have signed. And everything under.
The assignment has been properly done or not.
Yes,
The assignment
the
is
reference has been drawn properly or not, that much.
that has to be.
Yes.
I'm grateful.
Grateful, Mother, deeply obliged.
Item number 23.
Lord, my application under section 11, my lord. My lord, we have served the section 21 notice. It has been received. That would appear from the petition itself. My lord, service record is there. So far as this application is concerned, my lord, we have served now. Affidavit of service is on record. My lord, subsequent to preparation of the affidavit of service, my lord, the track record has also come, my lord, which shows it has been served, delivered.
my lord.
You should have
It-
filed the track record with this, sir.
My lord, track record, my lord. Actually, we had filed it, my lord, earlier, along with the affidavit of service, my lord. At that point of time, this track report was not available. It has been taken out subsequently, my lord. And section 21 service, my lord, would appear from, my lord, page 84.
You
21
file a fresh affidavit. We'll take it next week. Give it
incorporating the track
incorporating
report.
the track.
Lordship will do it. Kindly
Give it
keeps it
time.
next
Keep it
week.
next week.
Next week, my lord.
Next week.
Track report টা দিয়ে দিন। কেন?
Item number 24.
I appear on behalf of the respondent.
I appear on behalf of the petitioner, Your Lordship. I'm praying for an accommodation for 2 weeks.
Why?
Your Lordship, there are
But
talks
I'll
of
tell you, Your
settlement going
Lordship,
on.
what is the thing?
Yes.
Your Lordship was hearing this section 9, if Your Lordship remembers, on suit for land point. Mr. Aurik Banerjee was here. He was taking time. In fact, on the last date of section 9, my lord, they submitted before Your Lordship that serious talks of settlement is going on, and therefore Your Lordship was pleased to. Then what they come up with is, my lord, they haven't spoken to us till date, but they filed a section 11 application, and now that section 11 has come up. So he wants a 2 weeks adjournment. Let him, but my lord, let him at least do it seriously, my lord. Every day somebody new appears, makes some new statements.
No, Your Lordship, I'm being led by Mr. Banerjee only. I'm humbly praying for an accommodation for 2 weeks. The section 9 is to come.
Which Mr. Banerjee?
Mr. Aurik Banerjee.
25th, my lord, Your Lordship had said on 14 July, 6 weeks time, that would, my lord, take us to 25th.
So shall we keep it on the same date?
Very well, my lord, it'll be better, my lord. 9 can be disposed of. If, my lord, they want an appointment, we'll go by with an appointment.
In 9 we can appoint. Let them 9 be treated.
9, they can file a 17 before that, because they know the suit for land problem is there. So, my lord, now they want.
Learned counsel for the petitioner states that he is being led by, is he a senior advocate? Led by Mr. Aurik Banerjee, who's in some personal difficulty. He pays for an adjournment. Let this matter be listed along with, give the number.
The AP number 51 of
51.
2026.
51 of 2026 on 19th.
It's 25th.
6-week accommodation, Your Lordship. So
So what is
the
the date?
returnable date is 25th.
And Your Lordship, on 14 July, it said 6 weeks.
Generally, I give a date. There's no date.
No, my lord.
No, Your
This
Lordship.
one, this doesn't have.
All right. After, along with so and so.
Grateful.
Grateful.
Along with so and so. That AP number.
Item number 25.
My section 9 application. Lord, may I just give Your Lordship a
Development
brief
shouldn't be on the commercial side.
suit for construction and infrastructure, my lord. This is a my lord, agreement for construction over my land, subject to certain terms and conditions. My lord, purely a development agreement between my lord, a developer and a landowner, not my lord, for infrastructure. Possibly, my lord, 21C6 is passing through my lord's mind. Possibly, my lord, if infrastructure is not there, then my lord, mere construction may not my lord, attract. I can my lord, do a little research and come.
I think just do a little research so that we are sure about it, because this ground is enough to
Yes.
set aside.
Yes.
With
I-
the
my
division
lord.
bench judgment.
Nowadays, my lord, yes. My lord is of the view that my lord should come on.
I'm of no view. I'm just asking.
They will kindly, no. একবার দেখে নিয়ে আসি। Kindly allow us to come.
What is Mr.
Mr. Komokar is suggesting my lord, it can be converted today and
Just
Subject to what Mr.
just
Banerjee
see it,
Lord,
Mr. Karmakar.
there is a judgment passed by the division bench of Justice Bhattacharya, but which has treated, Lord, this construction contract, Lord, a development agreement, sort of development agreement to be a construction contract and then, Lord, relatable to commercial.
So just see that.
Yes, Lord. That's why I, Lord,
We'll keep it next week.
we can come back tomorrow also, my lord. Next week, very
I
welcome.
mean, my non-commercial is.
Oh, very well, very well. Because my lord, there are my lord, decisions which say my lord, unless my lord, this infrastructure element is not there,
Just verify that.
I'll just check it.
Check it so that.
every day, my lord, law is changing. My lord, I'll just check and come.
Not today.
Great.
Item number 26.
May it please, Your Lordship.
Yes.
But there's an application which we have taken out, my lord, for withdrawal of the sum which has been deposited before this honorable court. Now, my lord,
She
if
had
Your Lordship will,
short time to file.
Your Lordship, I filed my opposition.
we
They
are
were
not,
taking time
my
to
lord,
file.
filing a reply anymore because Your Lordship would be pleased to recall that filed an opposition. They've withdrawn that opposition to which we had filed a reply. Now they've filed another, my lord, affidavit in opposition where they've taken essentially two paragraphs are different. But rest everything is absolutely the same. These two paragraphs, my lord, hinge on the merits of the matter. My lord, they say that whatever you've made a claim before the MSME Council, that figure is wrong. So they can't really go beyond the, my lord, award right now because Section 34 is not entertainable as of now. No 75% deposit has been made. Very interestingly, my lord, one line they have stated in this affidavit where they say that this honorable court has to decide whether this amount is 75% or not. I agree with that. Hence, my lord, we don't really need an affidavit in reply to that. All that I'm praying for today at this stage, my lord, we have taken out this application. This is only for the, my lord, purpose of withdrawing, my lord, what they have deposited without prejudice to our rights against a security. We are giving a bank guarantee, my lord. So the other points they've taken in the affidavit in opposition is that you have a precarious financial condition. Hence, this should not be permitted to be withdrawn. My lord, we are giving a security. There's nothing that remains thereafter. My lord, we are securing the entire amount with a bank guarantee. My lord, kindly permit us to withdraw this and utilize. That's the, because it's an MSME entity. And also, my lord, may I only pray for this indulgence. If your lordship is pleased, my lord, to fix the Section 34 anytime, because, my lord, after the NBCC judgment, which has now been followed, my lord, their only point that they have taken is that this entity was not registered at the time when they approached the MSME Council. After NBCC, which is being followed thereafter, this Section 8 and Section 18 point is gone. There remains nothing in the matter. This matter can be decided any day by your lordship. We are carrying those judgments also. But unless, my lord, the 75% pre-deposit has been made by them, this has not been made yet. And this is an award of 21, my lord. May 2021. It's 26 that we are in. And all that they have stated in the affidavit in opposition is that whenever we wanted to deposit, you did not take the amount. It is not for us to take the amount. We have always maintained that this is not 75%. That we maintain even now. That this is not 75% of the awarded sum. So today, my lord, if they want to go behind the award saying that what you have claimed before the MSME Council is not correct, that's at the Section 34 stage, which will indicate they can't take that point at all. But today, this application may be, my lord, permitted. This is an application only, my lord, if your lordship kindly takes up page 7, where we have made the prayer. This is can 2, right? GA1. GA1, my lord. GA1 in AP 7.
This is GA1, right?
In AP 758 of 2023, my lord.
Page 7.
Page 7, my lord. The respondent, without giving up its right to contend, as stated aforesaid, where we have stated that it's not 75%, prays for a direction to permit withdrawal of this amount and other appropriate reliefs. My lord, we have stated here that we are willing to secure this with a bank guarantee. I'll indicate that also, my lord. My lord, paragraph 3 at page, my lord, 3 is where we indicate this is the sum that's coming to. And, my lord, paragraph 6 is the award. The deposit is recorded at paragraph 10. And we have disputed at paragraph 11 that this is not 75%. We are also carrying two judgments given by your lordship, my lord. In fact, our case is a little better here, my lord. There was 50% cash and 50% bank guarantee. And there was a dismissal in between, my lord, for default. Yes, absolutely. Give me a copy.
Page 3, first paragraph on it. Give me the quote statement. Motion that there is a no, the one that you
Yes.
My lord,
Your Lordship,
two more judgments may I hand over? Your Lordship, one is BBM Enterprise, where my lord, this issue is decided and discussed. This is the NBCC point,
Yes.
paragraph 5, my lord, on the second
the
page.
citation.
I'll give you a copy. Whether permitting award holder to withdraw secured amount, request statutory sanction, it is held, it is not required. Paragraph 10 and 15.
6, 10, 15.
16 and 15. And allowing withdrawal is paragraph 16 onwards. And the denouement of the judgment is paragraph 24. Here the court has held not a no separate application is also required. Let me just the post judgment. Take it out now beforehand. Thanks. My lord, the next judgment is Dilip Kumar Chatterjee. Give me. Paragraph 5, my lord, this provision is set out, and paragraph 7 onwards. Seven, 8, 9, and 10. If you want to take pick up. Or no more judgment other than this one. Yes. So the last judgment, Telangana High Court, paragraph 8 onwards, 1 page essentially, my lord. 2 pages.
Which para?
Paragraph 8 onwards, my lord. Paragraph 9, it was 8 years in that case. Here we are almost 6 years, my lord. And here it was without furnishing any security, that's paragraph 11, my lord. It was stated no security is required. My lord, in fact, we have not made that pleading specifically in our petition that we are, my lord, willing to secure with a security. But my lord, if it falls from your lordship, we'll do that, my lord. That's a specific prayer we have not made, my lord, in the petition. When an MSME entity, that's my prayer, man. That is my prayer.
Lordship, my objections may be recorded that my main plea is that if they furnish a bank guarantee, we lose out on the interest that is right now the amount occurring. That may be recorded and your Lordship may be pleased to pass necessary orders. Musical matter.
Catchy number. Yes.
Your Lordship, once the amount is deposited, we are earning an interest in that. Once they take out that money and they give a bank guarantee, but we are losing on the interest part. That objection may be recorded.
Anything below, they have not paid for 6 years.
They're not
Yeah.
entitled to any
only-
amount, and our section 34.
Where's the reply?
Your Lordship, The reply is the voluminous document, Your Lordship, on the right.
This is the reply.
Because
This
Your
is the
Lordship,
reply that is why we are not using
Your
the
Lordship,
affidavit.
we have included their balance sheet in
They
this.
have included 5 years balance sheet and profit and loss account to show, my lord, that we are struggling financially, which supports our case essentially. That's the case that we are making out. My lord. There's also a reply in effect, my lord, an opposition and a reply in effect.
All right, I'll pass an order.
I'm very deeply obliged. And my lord, may I only pray, my lord, very humbly, if my lord, the section 34 is taken up any day, my lord, we'll come back and argue the section 34.
34.
My lord, before that,
We are trying to keep a day for 34.
my lord, before 34, my lord,
3 p.m. Non-commercial 3 p.m. We are trying to keep it, so we'll try to.
my lord, before the 34, my lord,
What is
perhaps
the date
one.
of the award?
The award is 12th May
12th May
2021.
2021. My lord, may I only, my lord, pray for this indulgence?
Awards of 2007, 8, which are pending.
My lord, before the 34 is, my lord, taken up, will not trouble your lordship immediately. My lord, may I only pray for this? My lord, 75% has not been deposited.
Your Lordship, we have
And that
deposited
that's according to
75%.
them. According to us, it has
And
not been.
this
So, my lord, may I only
application,
pray?
the same prayer is not there that 75% is not
No, we have
deposited.
stated, my lord,
They have stated to which we have
we have
replied.
stated that, my lord, this is
We have
without
given a
prejudice to our rights. This is not 75%.
Your
May I
Lordship,
only
we have
pray for
given-
this indulgence if the matter is taken up? And, my lord, if because we'll
75% has to be there.
Your Lordship,
it has to be, it is not.
we have deposited more.
We'll show the calculation. Let them show the
We have
calculation.
given the
because
calculation.
It has to be
They have-
decided by
Your
the
Lordship,
honorable
in this
court, my lord.
opposition,
Whereas
we've given the calculation which they are not denying by not filing a reply. They have chosen not to file a
Yes,
reply.
we have indicated, my lord, that this is in the petition. We have stated that this is not 75%.
But we have denied and we have given a calculation
has
to
to be,
which
my
they
lord,
have
then
not
decided.
replied, Your
So
Lordship.
what is the figure? And according to them, what is
My lord, our 2 crore 11 lakhs is the figure, my lord, till
And we have deposited 180,23074, which, and we've given the calculation by a chartered accountant as how the calculation has
till
come.
June
Page 17 is
2026,
the
my lord, we have stated
calculation of the chartered accountant.
it's 2 crore 11. And we have also, my lord, relied on our calculation of a chartered accountant that this has to be the figure. Now, they have stated in the affidavit in opposition that this has to be decided by the honorable court. We also accede to that, my lord. That if both the parties are at loggerheads, this is not 75%.
We have stated
Then, my lord, there has to be a way out as to what is the 75%.
Deposited more
Till
than
then, the
the
34 will not
75%.
be entertainable. That's the reason.
It should be decided among both of you.
We have given them our chart, my
Than
lord.
burdening the court
No, I understand that,
with
my
the
lord. I understand.
calculation.
We have indicated time and again. In fact, your lordship will be pleased to recall there was a time when my learned friend had appeared and said, yes, there's a mistake in our calculation.
Yes.
We will now they resile from that.
Your
They
Lordship,
renege from
that is the
That's
reason I
that's
have
something we can't
included
tell.
the chartered accountant's certificate. Page 17 in the opposition is the certificate of the chartered accountant, because I cannot give a calculation based on maths. What is the 75%?
We have given based on
RBI
maths.
rate?
But you want
We have given
the
based on maths.
court to do.
Your Lordship, I have not stated that the court should do it. It is their submission. I
That's
have
a
stated-
record. It's
Your
in
Lordship,
your affidavit. My lord, can you take up the affidavit? I'll show from the affidavit. It's
we
clearly
have
there.
stated it is more than the 75% that we have deposited.
And that is the reason, my
Page
lord, I
7,
said.
Para 17, page 10, it is admitted fact that the petitioner has deposited a sum of rupees itna with the registry. It is further admitted said amount is in excess of the 75% and has been deposited in compliance of the mandatory requirement of MSME Act for the establishment, entertainment of the petitioner section 34 application. Para 17, page 10.
Your lordship will kindly take up. This is their submission. This is not our submission.
So why don't you file your reply to this?
So the reply is ready. It is being affirmed. My lord,
File your
if
reply.
your lordship kindly takes it up at 2 o'clock, we'll file the reply then, my lord. Kindly take it up at 2 o'clock.
Takes it next week.
Next week. File your reply. Learn it.
We need to also see the reply.
My lord, we have. My lord, may I pray for this indulgence if it is taken up tomorrow, my lord? We have
Your
the
Lordship,
reply.
they'll file the
On
reply. I need to see the reply
week.
once.
Learned counsel for the petition seeks and is granted. 3 days.
My lord,
3 days to file your reply.
do it today. Today, my lord, we'll do it today.
Within 3 days to file 3 days to file reply to the affidavit in opposition. List next week.
Next week, my lord. I'm very deeply obliged.
GA1.
The next two matters are, my lord, connected matters. One is a 34, my lord, and the other is, my lord, a 36.
Execution.
Next week.
Deeply obliged. My lord, the only
I
difficulty,
don't
my lord,
need to tag this 34 and 36 together now. So 34, 36. will be heard only once that 75% issue is resolved.
Yes, my
We'll
lord.
keep it next week. Then next week.
Lord, then may I, my lord, because both the parties are not, my lord, ad idem on the figure, then perhaps, my lord, we'll take out a short application, my lord, and we'll bother your lordship once for the figure, my lord. We'll do that. I'm very deeply obliged, my lord.
I'll dismiss the application with cost and send you to chartered accountant.
Deeply obliged, my lord.
I wish I would have studied maths.
My lord, we'll again, my lord, serve, my lord, we'll make over a copy of our calculation. We'll do that. It's a repeated attempt that we have, my lord.
Mathematics is something which, calculations is not my forte at all.
We will, my lord, make over a calculation again.
Get a
and
good
we'll come
chartered
back.
accountant, both of you, and come up with the figure so that it can be sorted out.
My lord. We'll do that. I'm very deeply obliged.
Item number 29, 30.
Next. Well, I appear for the petitioner, my lord. There's an application by the respondent, my lord, seeking leave to withdraw the amount deposited by us.
Not here.
Not here, my lord. 29, 30 are similar matters, my lord.
None for the respondent. In the interest of justice, adverse orders are deferred.
Well, none for the
करना, दोनों में. GA1, J1. List after 4 weeks. Monthly list of September. I'll come back.
30 also. Yeah,
Item number 18.
And I am for the petitioner.
Yeah, appearing in virtual.
In item number 18, my lord, I beg to appear on behalf of the petition respondent, my lord. In earlier occasion, the matter was taken up for hearing. My lord, we have consent to appoint an sole arbitrator, my lord. As per my lord's choice, my lord may appoint one arbitrator, my lord.
My lord, independently, my lord, upon an arbitrator, my lord. I have proposed a name though.
How much is
My lord may select independent
value?
arbitrator, my lord, irrespective
My
of
lord,
any selection from the part of this.
there is no, my lord, exact valuation because that is, my lord, arising out of a partnership agreement. A dispute in between is, my lord, regarding the disclosure of bank accounts and other, my lord, assets, my lord, of the partnership firm, of the business of the partnership firm, my lord.
Your 21 notice.
My lord. That is in page number 117 onwards.
Volume 2. 117.
117.
Take down. The petitioner prepared the present petition under section 11 of the Arbitration Consideration Act 1996 seeking appointment of a sole arbitrator. Where's the term clause?
My lord, in partnership agreement, clause 24, page number 36, my lord.
Seeking appointment of a sole arbitrator to adjudicate the dispute that have arisen between the petitioner and the respondent number 1 in relation to the functioning of the partnership firm Ma Tara. MS Tara Ma Kishan Seva Kendra. Learned counsel for the petitioner submits that the parties had entered into a partnership deed dated 17/10/2023, which contains an arbitration clause 24. Full stop. Dispute and differences have arisen between the parties during the course of the said partnership firm. During the course of the operation of the said partnership firm, the petitioner had invoked arbitration proceedings by issuance of a notice under section 21 dated 13/2/2026. Learned counsel for the respondent number 1, by reply dated 13/3/2026, had acknowledged the existence of the dispute between the parties, however did not take any steps for constitution of the arbitral tribunal. Learned counsel for the respondent states that he admits the partnership agreement as well as the arbitration clause as contained therein. Full stop. Learned counsel for the parties submit that they are agreeable to appointment of a sole arbitrator to adjudicate the dispute between the parties. Full stop. With the consent of the parties. Mr. Tell me, any name as such?
It might be, my lord, learned senior counsel, Mr. Sagar Bandyopadhyay.
Yes,
Or my lord, Devajyoti Basu is.
Mr. So and so is appointed. What's the name?
My lord, Mr. Sagar Bandyopadhyay.
Senior advocate.
Senior counsel, my
Give
lord.
the name.
My lord.
My lord, instead of him, my lord, can it be Loknath Chatterjee, my lord? Loknath Chatterjee, my lord.
Yes, senior advocate.
He is not a senior advocate, my lord, but the dispute is not, my lord, is that the appointment of a senior advocate is.
Mr. Rangnath Chokar, give the details of the concerned.
Yes, my lord. I will provide, my lord.
Is appointed as the learned sole arbitrator to adjudicate the dispute between the parties.
Grateful to your
The
worship.
arbitrator shall enter a reference in compliance with section 12 of the said act. He shall be entitled to fix his remuneration in terms of the fourth schedule of the said act. A copy of this order shall be communicated to the learned arbitrator to take necessary steps. With the aforesaid direction, the present petition stands disposed.
Grateful. নামটা
Item number 31.
My lord, I am appearing for the petitioner, my lord. My lord, this is an application for stay of an arbitral award.
My learned senior friend starts, may I request your lordship to take up item number 72 along with this? Because this is the section 36 and the item number 72 of today's lordship is the section 34 lordship, where we have taken the point of maintainability.
Yes, I shall reply the point of maintainability. So far,
affidavits have been filed.
No, lordship, there was no direction for filing the affidavits. On the first
so
occasion,
far-
lordship, I have indicated the.
72. Give me 72.
so far, my lord, my learned friend is concerned. What I have understood, my lord, from her submission in previous 2 or 3 days, my learned friend has raised a preliminary objection regarding the territorial jurisdiction. According to my learned friend, since in the agreement there is a clause that the place of arbitration should be Mumbai, my lord, it is clause 18 of the agreement of Schedule 1 of the agreement, my lord. Since the place of arbitration is Mumbai, so the arbitration should be held in Mumbai. To that, my reply is that even though the
Arbitration was held where?
arbitration was held in Delhi, my lord, that also Mumbai.
As venue.
Venue was in Delhi.
In Mumbai, lordship.
Seated in Mumbai.
Then how is this maintainable here?
My lord, it is maintainable here just because the cause of action has arisen here. In support of my contention, my lord, I would like to rely upon an authority, my lord, of Supreme Court.
Yes.
My lord, this is 1989 Supreme Court, my lord.
89 is too old, sir. You should see the new laws.
89 is Supreme Court, but it is pat on the point, my lord. It supports my case.
The seat being decided. Show me, Srijani.
Lordship, on item number 72, on the last occasion, I had handed over the entire copy of the agreement because the agreement which is annexed with the section 34 application that doesn't have the schedule.
My lord, the 89 maybe the judgment which has I am referring to.
Let me see the. Yes.
Lordship is having the section 34 application.
Yes.
Kindly comes to page 16, Lordship, first.
Page 16.
Page 16.
34 here, na? AP10. AP10 is 34.
AP10 is 34.
Page 16.
16.
Yes.
At the right below the right, Lordship will find clause 29 is the arbitration clause. And from the 15th line, Lordship.
No, where are you reading? Page 16?
Page 16.
Yes.
Right side below.
Right
clause 29. Arbitration.
Fine. It might be different page. It's page 17. Page 17. It's okay.
Lordship.
It's
So,
page 17.
29 is the arbitration clause, and from the top, if your lordship kindly come.
Settled by arbitration to be
Yes,
held at a place stated in clause 18 of the schedule 1 hereto in accordance with the principle and so on. Yes.
Lordship. So
Yes.
clause 18 of the
Schedule. Yes.
Lordship, it says the place of arbitration, the seat.
Has he annexed the schedule?
No, Lordship. On the last occasion, I had handed over your Lordship a copy. And
I need
my
to put
Lordship-
the entire agreement, sir.
My lord, the entire agreement was not handed over to me. I have annexed the agreement, portion of the agreement which was handed over to my client. That was supplied to me and I annexed her. Anyway, I will reply to her submission, my lord. The stand taken by her, since it is written in Mumbai, can only be held in Mumbai. It does not stand in the eye of law. I shall distinguish, my lord. I am armed with the judgments of Supreme Court, my lord.
If I may hand over the entire agreement, Lordship. Only the middle page of the schedule is not there in the petition. I don't know how my learned senior friend is submitting that the entire agreement has not been provided. All the previous pages and the after pages all are there. Not only the schedule page.
Anyway, I will distinguish, my lord.
Yes. Where is
Your Lordship kindly comes to the second page of the schedule, the clause 18, Lordship.
Clause 18, my lord, Mumbai.
place of arbitration, it is written as Mumbai, and there is this is duly signed by the petitioner.
Yes. All right.
Okay. Now, may I reply?
Your time, you
Okay.
are in a hurry. There's a problem.
No, no.
Then
Oh.
let her make a submission. You
Okay.
rebut after that. Yes.
Lordship, since the place of arbitration is in Mumbai, so this honorable court doesn't have the jurisdiction to entertain this section 34 application. Lordship, that was my maintainability point.
So you should have supplementary affidavit. Somebody has to place this on record.
Lordship, we may then file a short affidavit on the point of maintainability, since there was no direction on the last occasion.
Take down in AP 10, item 72. Learned counsel for the petitioner has filed the present petition under section 34 of the Arbitration and Conciliation Act, seeking setting aside of the arbitral award dated 28/8/2025, passed by the learned arbitrator, learned sole arbitrator, full stop. Learned counsel for the respondent states that the petition does not contain the entire term loan agreement, full stop. She further contends that the Schedule 1 is not annexed. Schedule 1 of the term loan agreement
Yes.
is not annexed with the petition, full stop. She states that in the said schedule, the place of arbitration is mentioned as Mumbai, full stop. In view of the said fact, she states that the present petition is not maintainable since the seat of arbitration in terms of the term loan agreement is stated to be Mumbai, full stop. She seeks and is granted liberty to file her affidavit in opposition, bringing on record the entire term loan agreement entered between the parties, full stop. Learned, this court puts a question to the learned counsel for the petitioner that why he has filed this petition bereft of material particulars, not annexing the entire loan agreement which has been entered into between the petitioner and the respondent, full stop. Learned counsel for the petitioner states that his client has only supplied the agreement which has been annexed with the petition, full stop. Since the petition itself is bereft of material, I'll dismiss it.
My lord, kindly do not dismiss it. I have some
particulars,
My lord, kindly let me make some submission, my lord.
not putting on
My lord,
record
this is not justice to me, my lord.
the entire agreement which has been entered into between the parties.
My lord, let me make some submission, my lord.
Present petition is dismissed for not bringing on record the entire
My
material.
lord, it is not my fault, my lord.
The learned, so you should be punished for your fault. The learned counsel
It is not
for the
my fault, my
petitioner is granted liberty to file a better petition with better particulars, bringing on record the entire document on which he wishes to rely upon. The present petition is dismissed. What hata do that she wants to file a
My lord, kindly do not dismiss this, my lord. I'm sorry, it is not my fault, my lord. They didn't supply me. If your lordship wants to,
when you come to the court, you
Let
have
it-
to carry out the exercise
no,
of getting the documents.
no,
You
how can I
cannot
get?
file a petition.
My lord, how can I get the documents without the? Let me. I'm ready to file affidavit, my lord,
You
to this
write-
effect.
You write a letter to them. I don't need to tell you how to get documents. All right. This is
If
not
your
my
lordship so
job to
directs
tell.
me, I can file affidavit to this effect that they didn't supply me the entire document.
If you want, I can dismiss with cost.
My lord, kindly do not cost, my lord. Sir.
You file a petition.
Yes.
Without
Then, my lord,
ma-
kindly give me.
Wait a minute.
What?
Without material particulars, I can hold it against you that you are trying to play a fraud upon the court.
No question of playing fraud upon court. I have not.
I record that.
I have no question of playing fraud on court. I have not tried.
Better withdraw and file with better particulars.
Better particular, my lord, in that event, my lord, can you give me liberty to file the fresh application with containing the limitation, my lord, delay period, my lord. There will be delay, my lord.
Why have you filed a petition without material particulars? Where is the
Just because I didn't have those particulars.
Am I concerned with that?
Just because I didn't have that.
You will file anything in the court.
Just because I didn't have that.
You will file anything in the court.
No. I filed only the material which was available to me, my lord.
Take down. I'll dismiss with cost.
Can it not impose cost, my lord?
This approach is not right. The petition, the Section 34 petition has been filed, challenging the award dated so and so.
Then, my lord, can you give me liberty to file a fresh application with?
The perusal of the record shows that the petitioner has filed the present petition without annexing the entire document on which he wishes to rely, particularly the term loan agreement, wherein the arbitration clause and the seat of arbitration has been mentioned. Learned counsel for the petitioner seems to have played a fraud on this court by withholding material particulars to
Lord, can do not make this observation, my lord.
To impress upon this court.
My lord, I have never tried to impress upon the court, my lord.
Exercise its jurisdiction.
My lord, I'm very ready to apply to the jurisdiction clause, my lord.
34 of the Arbitration Conciliation Act. Full stop. Though a copy of the term loan agreement has been handed over by the learned counsel for the respondent, wherein this court observed that the seat of arbitration has been mentioned as Mumbai. Full stop. The conduct of the petitioner is deprecated and the present petition is dismissed with a cost of 50,000 rupees.
Can do not?
Oh no, this is not right.
Can do not?
Dismissed.
I don't know.
36-2, in view of the same, since in APCOM so and so, the matter has been dismissed. The same is dismissed. What is this? You file a petition. And you are trying to tell me that my client has not given, my client has not given.
My lord,
Is it my fault your client has not given?
My lord, I will
Your client is playing a fraud upon you, and you are playing a fraud upon this court.
No, I'm not playing a fraud, my lord.
Then
my
who
lord,
is responsible for this?
My lord, kindly appreciate one thing.
Who is responsible?
No, my lord.
Who is responsible?
My lord, I'm taking the responsibility on myself, my lord.
Then withdraw the petition and walk away.
My lord, kindly appreciate one thing.
Sir, please don't.
My lord, kindly appreciate. I will apply.
Don't.
I apologize.
You are irking. Please don't.
Kindly do not impose the cost, my lord.
I don't wish to, and I don't do it. You're forcing me to do it.
My lord, do not impose the cost, my lord.
First of all, you make a mistake.
Kindly do not impose the cost.
Impose the cost. At least understand what you're doing.
Yeah.
Item number 32.
But I appear for the award holder.
Lordship, Mr.
I am opposing this.
This is that matter where they had taken the point of maintainability of the execution. My GA application is for substitution. This is an execution filed in September of 2018. Award is of 2016 for money. Series of orders passed by the executing court.
You're saying something?
Yes, my lord. Since I had taken the point of maintainability, my lord, would it be lordship special to, my lord, permit me to indicate, my lord, the point, my lord? But I am taking the point of maintainability of the execution application per se. But my contention is that, my lord, since after the coming into effect of the, my lord, Commercial Courts Act, and the notification by which the Calcutta High Court was where the commercial division was established in this honorable court. After that, this application was filed. So, my lord, the filing per se is, my lord, wrongful, and so it is not a pending proceeding within the meaning of Section 15 of the Commercial Codes Act, by which it can be transferred.
Yeah,
My lord,
I
as
think the division bench of Justice Basak has.
Yes.
Fine.
So, my lord, we are carrying that judgment. If your lordship kindly permits, my lord, my advocate on record to hand up a copy, my lord.
Compilation.
There's a compilation.
There's a paragraph. Have you seen it?
Yes, my lord. They had placed it on the last day. My lord, I said I'll consider this and come back.
Have you seen it?
Yes, I have.
It is very clear.
But I'll distinguish. I'll try, my lord. Will kindly give me a chance.
Don't do this academic
No, my lord.
exercise. If you
I'll
think
take
you can
only 5
file
minutes.
it
I
and
will.
There
I
is
will.
no problem with your limitation and other things.
There isn't. My lord, I'm convinced. I'll try to satisfy your lordship.
See, if there's a problem with your limitation, I understand you want to argue it. But if not, then you can withdraw it and you can file it in the commercial.
No, my lord. There is no such issue with limitation.
Then don't do this academic exercise.
I will show your lordship that this judgment is distinguishable. Our practice directions are also very clear, which has been noticed by the division bench.
All right. Yes, Mr. Gupta. Tell.
Yes, my lord. If your lordship kindly takes a look at the compilation once, my lord.
Yes.
My lord, we'll kindly have a look at the notification dated, my lord, 16th of July, 2020, 2016.
16th of, yes.
Now, your lordship would find that by this notification, my lord, the commercial division in this honorable court was established, my lord.
Yes.
But I'm led by Mr. Thakkar, my lord. I find he is there, my lord, lordship.
Sorry, it's very convenient to have courts on next door to each. Your lordship's fine. 16 July 26, commercial division, 2016, commercial division established.
Yes.
So now, my lord, this application is filed after this execution case is after this date.
Yes.
So there is a commercial division.
This is filed on
This is filed in
2018.
Yes, 2018. The
Right?
case status shows filed on registration date 19 September 2018. Admittedly, a commercial dispute.
Yes.
Now, my lord, the practice directions which have been framed by the full court, my lord, kindly have the practice directions. Judge साहब को दिया है practice direction? It is there, my lord, at the last. 6 to 19, please, my lord. Kindly have part 2, rule 4.
So your AP was transferred on the commercial side.
Well, that AP.
Well, the 34, yes.
It's the 34, not the EC.
Yes.
That's what I'm saying.
Yes.
That's the reason I'm asking him.
Yes.
So you agree that AP should be on the commercial
No,
side?
this should also be transferred. They are saying it cannot be transferred. It has to be dismissed. That is where I'm joining issue.
There I say it should be
I am with
dismissed.
Mr.
Dismissed. Kindly have the practice directions once.
Because of Justice Basak's judgment.
Justice Boshak, then there's a coordinate bench judgment and the rules framed by your lordships will provide for it. Kindly have, my lord, the practice directions. Kindly have page 7, please, my lord. Part 2, rule 4.
Transfer of pending cases?
Yes, please, my lord. Kindly have serial 2, please. 1 provides for transfer, 4.1 provides for pending cases which are transferred. Now kindly come to 2. The above provision for transfer shall not be applicable to suits, appeals or other proceedings instituted before any civil court as per so-and-so or in the High Court in its ordinary original civil jurisdiction after the date of issuance of the appropriate notification, the pecuniary value in terms of section 3.1a. So provision for transfer.
So 3.1a was issued on?
3.1a is issued, my lord, on. Give me a minute.
16 July 2016. That is the note.
July 2016.
Yes. That notification.
Where is that?
Page 2, my lord.
So page 2 is this is establishment of the commercial court.
Yes.
Notification in terms of section 31A. When was that done?
Now, copy that.
Section 1 of 3.
Or compilation that I
No, there's one more missed.
Yes.
Well, I'm carrying.
There's page. There's one
What
more.
is the date?
You missed.
That is November 2018. I'll just hand over a copy.
You missed it. Why have you not given the full set? एक मुझे
Copy টা দাও না।
Give it.
এটাতে আছে না, এটা তো practice directions.
Where is the mail which I sent you, madam? Why have you not print the full thing?
এটাতে কোন পাতা? Pardon me, Mala, this is part of a compilation. I'll turn it over to the relevant page. This is notification. At the top, your lordship will find in exercise of powers conferred by subsection 1A of section 3. This is 15th of November 2018.
Where's the date on this one?
Well, right at the top, your lordship sees number so and so, the 15th November 2018, after notification. The body, the first words at the body, after notification, it says number 254-0L 15th November 2018.
And yours is
Mine is September, 19th September 2018. And this is the cutoff date, Mala, that even the practice directions notices. And Mala, series of decisions, coordinate, division bench. But even in fact, this judgment that my learned friend cited on the last occasion, Mala, paragraph 65 and 67.
Just see this, Mr.
I'll just see this one second. ये तो हम तुमको दिया print लेंगे.
Yes, this is the pecuniary notification, which the practice directions also talks about.
Yes, my learned friend is right.
And it kindly sees paragraphs 65 to 67.
He's right. It's a case for transfer.
It has to be transferred. And it counsel for the parties submit that the present matter pertains to a commercial dispute. Let this matter be transferred on the commercial side in terms of section 2(1)(c) what?
Can you give me a minute, madam? There is one coordinate bench. That's a copy. Where this notification has been considered. Sorry. Kindly have this one.
It's Siemens.
No, JK.
It's a appeal.
JK.
I was just gonna say, Mr. Thakkar, I was just gonna say we should have more counsels like this, like you, but you are handing over.
Madam, I am prompted, madam. They say that this I should not give up, but
not giving up. It's just being fair.
It's being fair, madam.
It's
I
not
had
giving
given
up
that.
at all.
Yes,
It's just being fair, nothing else.
but I want to be. But this notification now kindly come to madam JK and
JK,
kindly have page paragraph.
Mr. Thakkar, why don't you do one thing? In all fairness, have a look at it.
May we come back?
Come back.
Yes.
Don't make me do this.
No.
And
I will. No, I will go through this. I'll go through this. I'm just handing
they are
it over.
very enthusiastic, you know. So
No, we have to be right
their
on.
enthusiasm should be handled by you.
Yes. We have to assist your lordship enough.
Absolutely. We'll have it next week.
এটা ফেরত দিন আমি দেখে
Because what he's saying is right.
No, what he's saying is right. Absolutely right. The specified value was notified prior.
So all the both the 34 and the 36 were all along tagged. They were being
Tagged together.
analogously heard. We
So that is the
genuinely,
reason why 34 are there. And there's a note
in fact,
from
Malad,
the
we were genuinely under the
you have
impression.
to you have to also see there's a note here. There's a note from the Chief Justice's office where the transfer had taken place on the commercial side. Yes.
And now, in fact,
This has to
after,
go on the commercial side. This is a technical objection which has come to somebody's mind later on.
in fact, Supreme Court now in the Bharat Heavy Electrical has also said that this technical issue, man, it cannot be. If the judge has determination and jurisdiction, it is maintainable.
Transfer करो, वो बोले commercial होगा but dismiss नहीं होगा transfer. I'll cancel. Apologies for wasting.
No.
But she's keeping it next week,
Next week.
Wait.
on Tuesday.
Wait.
No, लिखे थे. हरिये.
Item number 33.
Actually, ma'am, for the petitioner, your lordship, this is the affidavit of service.
What is this?
Lordship, this is the affidavit of service. It has the order dated June 20.
We'll have it after lunch. This is the third execution. Okay. We'll have it next.
I just mentioned one thing, my lord. Item 37, very quickly. The 98-year-old man, the SLP was pending. So, 90-year-old man, SLP was pending.
8
That-
have been added.
Yes, my mistake, which is why your lordship was adjourning the execution. Now, my lord, yesterday the SLP has been dismissed. Subject to your lordship's convenience, any day, my lord, the money is lying with the registrar original side. All your lord.
Chaudhary was appearing. Who was appearing on the other side?
Other side is state, my lord. They were taking time on the ground, my lord, that SLP is pending. To yesterday, my lord.
Mr. Sinha was there.
Yes, now of course he is not.
You are there?
I appear for the office of the additional advocate on record, my lord. My lord, yesterday the SLP was dismissed, my lord. My lord, the state has lost almost all remedies, my lord. We have today morning, my lord, instructed the department to, my lord, to pay off the amount, my lord. They have asked for some time, my lord.
How much time?
My lord, your lordship will give us a week or two's time, my lord, so that
2
they can proceed with the matter, my lord.
2 weeks or attach your account with the RBI.
Kindly grant us 2 weeks time, my lord.
Kindly pass an order.
No. 2 weeks. Come back after 2. Item number 1 for judgment.
I appear for the award holder in this matter.
In view of the dismissal of GA1 of 2023, the decree holders are entitled to proceed with the execution of the decree dated 10/12/2019 and enforcing the award dated 10/12/2005. This is the matter after 3 weeks.
I'm so grateful, Your Lordship.
Just check the
Item
name
1
of
and 2.
the lawyers and all. Item number 2 for judgment. In view of the dismissal of GA1, the decree holders are entitled to proceed with the execution of the decree dated 14/10/2015, enforcing the award dated 30/12/2005. Let's start with you.
Grateful, Your Lordship.
Check the names then. Item number 56.
Lordship, I appear on behalf of the award holder in this matter. Lordship, this is unilateral appointment. But I don't have any instructions to withdraw the matter. So Lordship may pass necessary orders.
Senate Counsel for the petitioner states that the present execution petition arises out of a unilateral award dated what is the date of the award? 27/3/2000.
Lordship, 27th March 2019.
In view of the judgment of the Honorable Supreme Court in Mathura International, as well as judgment passed by this court in such and such, the present execution petition, the present award is an honest in the eyes of law. Thus, the present execution petition is not maintainable. The parties are at liberty to file appropriate proceedings in a court.
Lordship may pass similar orders in item numbers 61, 62, 63, and 64. I'll
Just give the details.
Lordship.
Mathura International. Right.
61. Grateful, Lordship.
Item number 57.
For the judgment letter, the judgment letter is present.
But I have received the instruction to withdraw.
Withdraw, right? Senate Counsel for the
With
petition.
liberty to file.
Seek to withdraw the present petition with liberty wo jo nahi hai, liberty mein diya hai in all the matters.
And item number 58, Lordship.
57 and 58.
58.
Any other matter? Withdraw with liberty to. मुझे नहीं withdraw, dismissed. Item number 59. Item 59. Not waiting. None appears on behalf of the petitioner. Even on the earlier occasion, 14th May 2026, there was none appears on behalf of the petitioner. Even on the earlier date, 14 May 2026, there was no appearance on behalf of the petitioner. So closed. It seems the petitioners are interested in pursuing the present petition, so they will dismiss particular. Item number 60. Dismiss for default. इसमें कोई previous order है दिखाना. Item number. ये सेव करना लास्ट 14th में. And appeared on there. They also know obviously. Item number 61. 61. Item 61. Same. 61, 62, 63. Right?
63, 64, my lord.
63, 64.
Dismiss being not maintained.
Yes.
61, 62, 63, 63.
Item number 65.
I appear for the award holder, my lord.
I appear on behalf of the award holder. I'm filing my affidavit of asset.
There are two parts to the award, my lord. Some part payment was directly to be made to us. That has now been completed. So far as the money that they are supposed to discharge to the bank on my behalf, because they had obtained, I had obtained a loan at their instance and the money had gone to the bank. That part is still outstanding. I've just been served with a copy of the affidavit. My lord should fix it for examination, and if they can pay off in the meantime.
Kindly will give me some time. We'll try to make the payment as soon as possible.
Right. Affidavit of asset filed by the judgment data is taken on record. There's only one judgment data, right?
Two
judgment data.
Two, my lord.
Who has filed this one?
The judgment debtor is a company, so one of the directors
Company
is
has
filed.
filed.
Company has filed.
Is taken on record. This matter for examination of the judgment data on after
Kindly grant me some time, 2 months.
2 weeks, after 3 weeks.
Give me a month, your lordship. I will try to make the payment as soon as possible.
Month
If
will be
in
too-
that event, your
After
lordship,
3 weeks, we'll see your
Very
intention.
good.
Start
See the
making
bona
some
fide.
payment, so we see your bona fide.
Yes.
Then we can give you more time.
it is the bank. The payment has to be made together.
No,
Correct,
not
but then you have
necessarily.
to
It can be made in parts also.
discharge your liability.
I bow down to
See
you.
how you discharge your liability. Then
Yes.
we'll see.
Grateful.
3 weeks after. Item number 66.
Lordship, I appear on behalf of the petitioner. On the last occasion, the respondent had taken time to seek instructions what they're going to do with regards to the reference. What reference? Because it was a unilateral appointment. Your lordship has recorded that. Thereafter, they had taken some time. Then 2 occasions we could not appear. This is the 3rd time, your lordship. It is on record.
इसको dismiss कर दो.
Your lordship, please. I'm being led by Mr. Das.
Yes.
Is section 34 appearing at my instance, my lord? From 11th of March, they have been seeking time. I am not in the, because they had also not raised any objection. It's a unilateral appointment. My lord, here a section 17 order was passed. Therefore, thereafter a section 34 has been, award has been passed. From the award, we've come up in a section 34. The subject matter was also has been taken over custody by them, sold off. Money has also been recovered to their account. Some amount on account of interest. It was 11 lakh claim, 10 lakhs or 10 lakh 70 odd they have recovered. Some amount on interest is what was remaining.
I don't have any instruction regarding.
At least get the instruction so that what you want. Set aside. Come back next week, please. You know,
Last
take
occasion also, this was the same
so
prayer.
much time. Next.
My lord, I will.
Not this one. Item number 67. Yes.
Item 59, I appear for the petitioner.
59 gone.
No, sure, I was on my way.
All right. What do you want 59? Not today, Gardo.
Not today, Your Lordship. Just we are yet to receive the instruction.
Not today. Unilateral, I'll dismiss it. I've dismissed it. Not today, Gardo. Not. Hmm. 59. Item 67, 67. Okay. Item 67. 67 दिखाओ. Mention क्या है? And then they don't come. Very nice. $34, huh? Let's not dismiss it. Just keep it. None appears for the parties. Monthly list. सबका है award है. Award सबका है. More than 9. September. Item 58.
Lordship, I just got informed by his clerk that Joydeep sir is on his way. Joydeep Kaur, Mr. Joydeep Kaur. If the Lordship a short passover can.
Passover, wonderful. Next week. Next week.
In fact, my senior is also on the way. My lord is coming.
Very good. Both of them come next. Next. Item number 69. Item number 69. 69. The people mention the matter, then they don't come. I don't understand this. They're in such a hurry to mention, but when it comes to 34, nobody wants to do it. I should start dismissing it. Dismiss for default कर देता हूँ. Restored matter. None appears for the petitioner in the interest of justice. None appears for the parties in the interest of justice. That was all of that. Monthly test. Yes, Mr. Kar.
That 68.
68.
A very short point. We'll come back and do it next week. Your Lordship has kept it. It won't take more than half an hour.
Finish then next week.
Yes. But
Today I'm also slightly under the weather.
no problem. We'll do it next week. In fact, I am at fault because
No, not at all. I do have time, but
no, it's absolutely fine.
Your Lordship, we'll come back next week.
We'll do it. It's on a very short point. Specific performance decree has been granted by the arbitrator. Lord, the arbitrators has amended one clause in the of the contract.
But today I won't function to the best of
No,
my
I'm just giving your Lordship a glimpse of the matter.
We'll have it next time.
Much.
And even Mr. Kar, that the other matter was also there today.
That Tolerance Club. Yeah. So I'm very sorry, my lord.
We have kept it for some other day. We'll try to finish it off since you have filed a supplementary affidavit bringing on record.
I will definitely.
Right.
I got stuck, my lord. I couldn't come in the morning.
No.
Really sorry. Much.
Item number 70. Item number 70. Same order. Today we won't dismiss. We'll just. Wait. Amicably settled. Might have been amicably settled between the parties. ये नहीं आएगा कोई. Dismiss for default. Because it has been amicably settled between the parties.
On item number 60 there.
670, 70. Which one?
My lord, I appear in item number 60. My lord has possibly dismissed it for default. My kind, if my lord kindly keeps it not today, my lord, because I am told, my lord, I haven't gone through the brief. I have been told that it is possibly a case of unilateral appointment.
That's okay.
So, not kindly.
You are
keeps-
appearing for the respondent.
Yes, my lord.
What's your problem?
No, no, I am appearing for the petitioner. I am appearing for the petitioner.
Oh, yeah. Cholamandalam.
My lord, yes, yes.
You appear for Cholamandalam.
Yes, my lord. I've just
Are you
been
not-
briefed, my lord.
You're
Just
not
been
taking instructions. That's the problem.
Yes, my lord. I don't have instructions.
60 next week.
Yes, my lord. I'll make the necessary submissions, my lord. Because my presence.
Necessary submission is only one thing. What is your instruction?
I don't have any at this point.
But come back with the instruction.
Yes, please.
Item number 71.
Petitioner. I'm seeking adjournment for the day. I'm led by Advocate Abhishek Haldar.
Learned counsel for the party. Learned counsel for petitioner. States that the main arguing counsel is busy in another court. He prays for an adjournment. Let this matter be adjourned to the monthly list of. Item number 73. Right.
73.
Wish to appear for the appellant lordship, led by my senior.
What do you want?
Maybe taken up next week.
Next week. Not today. Item number 74.
Short Passover.
Not today. No. What are you waiting for?
5 and 6.